So you're contemplating retirement and you're also contemplating divorce. You're wondering, should I stay where I'm at? Should I start divorce in the state that I'm in, or should I move somewhere else? What do you do? My name is Carla Hartley. I'm the managing partner for Hartley Law Group, a firm practicing family and probate law in Texas and California. We have attorneys licensed in both states and attorneys licensed in either state. In addition to that, we offer pro hoc vice services for clients that may have issues going through more than just California and Texas, but including assets or businesses located elsewhere. Today, we're talking about one of the most important and often misunderstood issues in divorce, how pensions and retirement plans are divided. In particular, we'll compare California and Texas because that's where we're licensed and that's where we have offices. Both California and Texas are community property states. That similarity, that label, often leads people to assume the rules are the same. They are not. While both states treat retirement benefits earned during marriage as community property, the way the courts divide those benefits is very different from state to state, and those differences can dramatically affect outcomes. We'll walk through the basic framework, then take a deeper look at California, Texas, and finally the federal law that overlays both systems. Retirement assets are what we're talking about. When we refer to retirement assets, we're generally talking about two categories. First, defined benefit plans. These are pensions. They promise a future monthly payout, often based on years of service and salary. Second, defined contribution plans. These are accounts with an actual balance, like a 401k, 403b, and government thrift plans. We're also talking about individual retirement accounts, including traditional IRAs, Roth IRAs, SEP IRAs, simple IRAs, and any other IRAs that the government might come up with. In divorce, the core question is not whether a retirement plan exists, but what portion of that plan was earned during marriage. The big picture is whether we have community versus separate property. In both California and Texas, retirement benefits earned during marriage are generally community property. Benefits earned before marriage or after separation or divorce are typically separate property. Because retirement benefits often accrue over many years, courts must apportion the benefit between community and separate interests. This apportionment step is critical, and it's where formulas like the time rule come into play. California does a strict equal division of the community estate. California is a true 50-50 community property state. If an asset is community property, the court must divide it equally unless the parties agree otherwise. Caveat, or unless one of the parties is convicted of perpetrating domestic violence, felony domestic violence against the other spouse. That's a whole different video, and we're not discussing it here. California Family Code Section 760 defines community property. Section 2550 requires equal division of the community estate. Family Code Section 2610 specifically authorizes courts to divide retirement plans and pensions. Judges in California do not have discretion to adjust the division of the community property based on fairness, fault, or hardship. Equal means equal. Again, remember that caveat I mentioned earlier that we're not discussing today. Typically, California uses what's known as the time rule to divide pensions. Under the time rule, the community interest is calculated by taking the length of service during marriage and dividing it by the total length of service at retirement. That fraction is then applied to the benefit received. The non-employee spouse is usually awarded 1/2 of the community portion, and payment often occurs when the employee spouse retires and begins receiving benefits. This approach creates predictability, but it also creates rigidity. There's very little room for adjustment once an asset is classified as community property, particularly a retirement asset. Texas is more concerned with a just and right division. That is a statutory term, just and right division. Texas is also a community property state, but Texas does not require an automatic 50-50 division. Under Texas Family Code Section 7.001, courts must divide the community estate in a manner that is just and right, having due regard for the rights of both spouses. That language gives Texas judges broad discretion to consider fairness, fault, and future circumstances when dividing property, including retirement benefits. Texas recognizes that retirement benefits accrued during marriage are community property, even if the benefits are not yet vested or payable. The Texas Supreme Court's decision in Taggart v. Taggart established the use of a time rule formula to determine the community portion of a pension. Like California, Texas calculates the community interest by comparing service during marriage to total service at retirement. The math looks similar. The legal result often does not. In Texas, the time rule identifies the community portion, but the court is not required to divide that portion equally. Refinement through case law has affected this. Texas courts have refined this approach through additional case law, including Berry v. Berry. These cases make clear that both defined benefit pensions and defined contribution plans may be divided using a community fraction, and that courts have flexibility in how the non-employee spouse receives their share, either through future payments or by offsetting the value with other community assets. I want to talk about this briefly. This is a big difference from California, this discretion the courts have. In California, if you want to offset a pension or offset a retirement plan, very often the court cannot order it. It must be done by agreement. In Texas, the court can order such offsets. Now, what does just and right mean as a legal term in Texas? The phrase just and right is not undefined. In Murph v. Murph, the Texas Supreme Court identified a non-exclusive list of factors courts may consider when dividing community property. Non-inclusive means including but not limited to. These factors apply equally to retirement assets. They include fault in the breakup of the marriage and the economic circumstances of the parties. Fault matters in Texas. Infidelity is a common example. If one spouse's affair contributed to the breakup of a marriage, a court may consider that fault when dividing the community estate, including retirement benefits. Financial misconduct is another example. Wasting, concealing, or misusing community funds, sometimes referred to as financial abuse or fraud on the community, can justify awarding a greater share of community assets to the other spouse, even if the retirement account itself was not directly affected. Fault does not guarantee an unequal division, but it is a permissible and frequently litigated factor. Now, in Texas, a party can ask for a jury trial when dealing with fault. That's going to add to the expense. So you want an attorney that's going to talk to you about the potential expense of a jury trial in terms of attorney's fees and costs, and the potential gain from a just and right division that is ultimately at the discretion of the court and the jury. Now, let's talk about circumstances and equity. Texas courts also look at the parties' circumstances. For example, if one spouse has significantly lower earning capacity due to age, health issues, or years spent out of the workforce, a court may award that spouse a larger share of retirement benefits to help address future financial security. This ability to adjust for economic reality is one of the defining differences between Texas and California law. Now, that's with regard to pensions. The interplay here, and this is a different video, deals with the existence and award of spousal support in California, the non-existence really of spousal support, but rehabilitative maintenance in Texas. So there are strengths and weaknesses to both sides. If you're contemplating making a decision about choice of law, you want to talk to an attorney who knows the law in both states. So your takeaway for California and Texas when dealing with retirement plans: both states use a time rule. Both states determine what portion of a retirement is community property, but in California, the court is bound to equally divide the community estate, the community portion of the pension plan, absent an agreement of the parties to do otherwise. In Texas, the court has discretion to deviate from equal division of any retirement plan and can go with just and right and can apply offsets without agreement of the parties. All right, let's talk about the federal law overlay now, because all of this has to occur under the umbrella of federal law. Regardless of whether a case is in California or Texas, federal law controls how many retirement plans are divided. State court orders must comply with federal requirements or plan administrators will not honor them. Let's talk about ERISA and quadros. The Employee Retirement Income Security Act, known as ERISA, governs most private employer retirement plans, including defined benefit pensions and 401k plans. ERISA generally prohibits assignment of benefits, but it allows division pursuant to a qualified domestic relations order, or quadro. The quadro is required to divide ERISA-covered plans in both California and Texas. There are non-ERISA plans. IRAs and other non-ERISA plans will be traditional IRAs, Roth IRAs, SEP IRAs, simple IRAs. These are not governed by ERISA. These accounts are typically divided through a divorce decree or transfer incident to divorce rather than a quadro. However, strict tax rules apply, and mistakes can result in huge unintended tax consequences. So again, find an attorney that knows what they're doing. Understanding the differences between federal requirements, when federal requirements fall under ERISA, when federal requirements do not fall under ERISA, understanding tax consequences, understanding the differences of how each state is going to divide your retirement plans, pensions, or retirement savings plans is critical, especially for couples with assets or employment ties in more than one state. Thank you for watching. This presentation is for educational purpose only and is not intended as legal advice. It does not create an attorney-client relationship. My name is Carla Hartley, and I hope this has been helpful.